Today we begin a very important topic, which is on 505(b)(2) applications. These are also called as hybrid new drug applications. The importance of this topic lies in the fact that more and more Indian companies are adopting this regulatory pathway for filing the applications for new products in USA. This has become a very important business domain for the Indian companies, and they are utilizing the hybrid new drug applications more and more to make profits in the US market. In this class, we will be discussing all the aspects related to hybrid new drug applications. What are hybrid new drug applications? What are the requirements? What are the examples? And then later on, we will also discuss the case studies related to the hybrid new drug applications. We have discussed previously that there are mainly three types of regulatory applications that are used in USA for approval of the new products. The first one is called as the 505(b)(1) or the new drug application or NDA, where the full report of investigation of safety and effectiveness is submitted to the US FDA. These investigations of safety and effectiveness are carried out by conducting the clinical trials. And as we discussed, these clinical trials are conducted as phase 0, phase 1, phase 2, and phase 3 of the clinical trials. The other type of application which we are going to focus today is the 505(b)(2) or the hybrid new drug application. This is an application that also contains full report of investigations of safety and effectiveness, but this is the difference between the 505(b)(1) and B2, but where at least some of the information required for approval comes from studies not conducted by or for the applicant, and for which the applicant has not obtained a right of reference. What this means is that although the full reports of clinical trials for safety and effectiveness are submitted in 505(b)(2) application as well, some part of the data was not generated by the sponsoring company, the company which is submitting the hybrid NDA. It was neither generated by them, nor it was conducted for them by somebody, and neither they have the right of reference for this data, which means that this data comes from some other source. And what are those other sources from where this clinical data is taken shall be discussed in the subsequent slides. The third type of application is 505(j), which is the abbreviated new drug application. And this is an application that contains information to show that the proposed product is identical in active ingredient, dosage form, strength, route of administration, labeling, quality, performance characteristics, and intended use, among other things, to a previously approved product. And as I told, this is also called as a abbreviated new drug application. We will discuss about the ANDA pathway in detail in our subsequent slides. Sorry, in a subsequent lecture. The 505(b)(2) section was added to the US FDA Act by Hatch-Waxman amendments. These are the names of two senators who had prepared the amendments for the Drug and Cosmetic Act for the US FDA. or Food and Drug Administrations Act. The provision expressly permits FDA to rely for approval of NDA on data not developed by the applicant. As I mentioned on the previous slide, this data is neither generated by the applicant, nor it has been generated for the applicant, nor they have a right of reference to that data. The historical background for the 505(b)(2) Act is there used to be a FDA's paper new drug application policy, which permitted an applicant to rely on studies published in scientific literature to demonstrate safety and effectiveness of duplicates of certain post-1962 pioneer or innovator drug products. This means that this paper NDA policy allowed approval of the new drug applications based on the published scientific literature. Enactment of the generic drug approval provision of the Hatch-Waxman amendments ended the need for approval of duplicate drugs through the paper NDA process by permitting approval under 505J of the duplicates of the approved drugs. 505(b)(2) permits approval of applications other than duplicate drugs, which means other than the NDA, and permits reliance for such approvals on literature or on an agency finding of safety and or effectiveness for an already approved drug product. This means there are two sources or two tools which can be used for submitting the data for safety and effectiveness in the case of 505(b)(2). What is the first tool? The first tool is that literature published information can be used for submission of 505(b)(2). And the second is the industry agencies' previous findings on safety and effectiveness for an already approved drug product. So these are the two ways by which the data for the clinical studies can be picked up by the applicants of hybrid NDA and can become part of the dossier which is submitted for the approval of new drug product. A 505(b)(2) application is one for which one or more of the investigations relied upon by the applicant for approval were not conducted by or for the applicant, and for which the applicant has not obtained a right of reference or use from the person by or for whom the investigations were conducted. This we have already discussed, which means part of the clinical data that is used for the approval of 505(b)(2) application was not generated by the applicant and has been picked up from some other source. And what those two sources are: first one is the literature and the second one is the industry's previous findings on safety and effectiveness of a already approved product. What type of information can an applicant rely on for submission of their hybrid new drug application? It is dependent on the investigations relied upon studies not conducted by or for the applicant and for which the applicant has not obtained a right of reference. The first way from where the information is picked up is the published literature, and this is called a literature-based 505(b)(2) application. Now, in this case, a right of reference to the raw data should not have been obtained by the company who is submitting the hybrid NDA. If the right of reference has been obtained, then it becomes a new drug application or a 505(b)(1) application. Sometimes a new drug application becomes a 505(b)(2) application if any specific information for approval is falling under the same criteria, and even if the applicant has also conducted clinical trials to support the approval. This means that if some of the clinical data which has been submitted by the 505(b)(2) applicant falls under the category of either literature-based data or agency's previous finding, then that 505(b)(1) application shall be converted into a 505(b)(2), and it will be evaluated by the US FDA from that perspective. The reference to the published literature needs to be of very specific nature. For example, clinical trials, animal studies, etc., necessary for the approval of the application can be picked up from the literature and become part of your 505(b)(2) application. So this has to be a proper documented literature which complies to the regulatory requirements in terms of the clinical data. The second way the information can be picked up for the 505(b)(2) application is agency's findings on safety and effectiveness for an already approved drug product, which means the US FDA has already approved a product and the data which was submitted to support that application has been picked up by the hybrid NDA applicant for justifying their application. The justification for this, or why the US FDA allows this kind of practice, is that US FDA has been traditionally relying on agency's previous findings of safety and efficacy for another company's previously approved drug product in the case of ANDAs. Which means in the ANDA, the generic company does not perform their own clinical trials, and the clinical trial data that was generated by the innovator company is used by the agency for the approval of the ANDA application. However, this provision also applies when the two drug products may not be pharmaceutically and bioequivalent, which means that this provision can also be applied for products that are not generic products, which means that the agency's finding on safety and efficacy to the same extent as allowed in generic approval can also be used for approval of a product equivalent to the innovator product. This means it can be used for a product that is non-generic, or which is not a generic product. The sponsor needs to only generate additional information to address the issues raised by the differences between the two products. Since these two products are not bioequivalent, there are some differences in the profile of the two products. So to justify those differences, the company which is filing the hybrid NDA or 505(b)(2) will have to generate more information and apply it as part of the hybrid new drug application. This move by the US FDA is aimed at encouraging innovation in drug development without requiring duplicative studies to demonstrate what is already known about a drug, while protecting the patent and exclusivity rights for the approved drug product. This means the role of the hybrid NDA is to encourage the innovation in drug development and accelerate the process of innovation without the need for conducting duplicative studies that have already been done by another company while their new drug application was approved. When this 505(b)(2) process was started by the US FDA, there was a lot of protest and resistance from the innovator companies, and they had filed number of petitions or court cases to stop this process. And in a consolidated response to 4 citizen petitions issued on October 14, 2003, FDA has reaffirmed its interpretation of 505(b)(2) by re-emphasizing the previous 2 aspects and additionally saying that the 505(b)(2) applicant need not await approval of a generic version of the product before filing or gaining approval of its application. And second, also need not wait for FDA to clear its interpretation of the Federal Drug and Cosmetic Act with the public before availing itself of this approval mechanism, which means that they had upheld that the 505(b)(2) is a valid route of regulatory approval and the applications can be approved even if no ANDA has been approved for a innovator product. What kind of applications can be submitted under 505(b)(2)? There are various types of applications that are allowed to be submitted under 505(b)(2). The first one is the new chemical entities or new molecular entities. Normally, already published data is accessed if the applicant had a right of reference to all the information necessary for approval, even if the applicant had not conducted the studies, the application will be considered as 505(b)(1) application. So this we had discussed previously also, that the applicant should not have the right of reference to the literature data which is used for the approval of their application. The second type of application is changes to previously approved drugs. The sponsor may rely on US FDA's previous findings coupled with additional data to support change from the approved product. 505(b)(2) applications should be submitted only in cases where changes are not permitted under 505(j), that is ANDA are involved, because approval will require review of clinical data. An applicant can submit a 505(b)(2) application even though the application may also be considered under 505(j) to C, which is the ANDA with suitability petition. We will be discussing about ANDA with a suitability petition when we talk about the ANDA process in a separate lecture. Examples of 505(b)(2) applications include, so if a review of only bioavailability and bioequivalence studies and limited confirmatory testing is required, then the ANDA filing with suitability petition can be done. Following examples require a review of studies beyond those that can be considered under 505(j), which is the ANDA. Additional information can be based on literature, previous agency findings, and studies not conducted by or for the applicant, or to which it has not obtained the right of reference. Coming to the examples that are usually handled under 505(b)(2). First one is the change in dosage form. For example, if you change the oral product to a transdermal route. This will fall under 505(b)(2) because this cannot be a ANDA since the pharmaceutical equivalence is not there and the dosage form is different. For ANDA, the dosage form has to be the same. Change in strength, for example, change to a lower or higher strength. Since in the case of ANDA, the strength of the product should be the same. If we are changing the strength, it will go and fall under 505(b)(2) route. Change in route of administration, for example, intravenous to intrathecal route. Substitution of an active ingredient in an already approved combination product. If this is done, this will also fall under 505(b)(2). Formulation related changes. Proposed drug product containing a different quality or quantity of an excipient than the listed drug, where the studies required for approval are beyond those considered limited. Confirmatory studies appropriate for a 505J application. 505J is abbreviated new drug application. Changes related to dosage regimen. For example, change from twice daily to once daily dosage. Change in active ingredient. For example, using a different salt form, an ester or a prodrug, chelate, clethrate, racemate, or enantiomer of the active ingredient for preparing a new product will fall under 505(b)(2). For example, omeprazole is now also available as a enantiomerically pure product called as S-omeprazole. Similarly, there are other examples like ibuprofen, which are available in the enantiomerically pure form. So all these cases where there is a change in the API by way of salt formation, prodrug formation or ester formation, chelate formation or enantiomerically pure materials will fall under 505(b)(2). The reason for this is that in the case of abbreviated new drug application, it is mandatory that the API should be same as was used by the innovator company. If there is a change in the API, even by way of a different salt form, then it will be considered as a 505(b)(2) application, and additional studies of safety and effectiveness will have to be carried out by the applicant, or they will have to be picked up from literature or some other source for justifying the efficacy and safety of their product. So these are some of the examples where usually the 505(b)(2) route of application shall be applied. The other example includes new molecular entities. In some cases, parties other than the applicant might have done some studies on the proposed new molecular entity. This is particularly done in the case of prodrugs and metabolites. So for example, there is a drug product which has already been approved for the innovator company, and a company other than the innovator company generates a prodrug of that API. So in that case, some of the studies that were already conducted by the innovator company can be used for the justification of their application, and it will be falling under the 505(b)(2) route. Next one is the combination products, where the active ingredients have been approved individually earlier, but the combination is new. Say there is paracetamol and ibuprofen, which have been individually approved earlier, but they are not approved as a combination product. In this case also 505(b)(2) type of application would be applicable. A new indication for an existing drug. A very good example could be celecoxib is approved for rheumatoid arthritis. Its use for colon polyps is a new indication of an existing drug, which means some additional studies related to effectiveness will have to be demonstrated by the applicant company, and it will go as a 505(b)(2) application. However, if the applicant is the innovator company, then it will fall as a new drug application, because the innovator company has the right to that data which was generated previously for celecoxib. However, if a company other than the innovator company applies for this new indication, then it will be considered under 505(b)(2), because they do not have the right of reference to the clinical data that was previously generated by the innovator company. Prescription to over-the-counter switch are also taken under 505(b)(2). Sometimes earlier the drug product is a prescription drug product, but later on it is converted into a over-the-counter. For example, ranitidine 25 milligram was previously sold as a prescription drug product, but later it was switched to a OTC product. So this will fall under 505(b)(2). A drug product whose monograph is different from an OTC monograph will also go under 505(b)(2). Naturally derived or recombinant active ingredients are drug product containing active ingredient derived from animal, botanical, recombinant technology, where it is necessary to carry out clinical trials to show that the active ingredient is same as an active ingredient in a listed drug. This is applicable in the case of biotechnology derived product. If the active ingredient for the product is generated using a different process than the one which was used by the innovator, additional studies to justify or clinical trials to show that the active ingredient is same as an active ingredient in a listed drug will be required, and this will be considered as a 505(b)(2) application. Bio-inequivalent products, where the rate of extent of absorption is beyond the limits given in 505(j) or ANDA. Additional clinical studies are required to document the safety and efficacy. This change should be reflected in the labeling. The product does not need to be shown to be clinically better than the previously approved drug product. However, this route should not be used to file poorly bioavailable generic products. Another example is a 505(b)(2) product may be appropriate for a control release product that is bio-inequivalent to the RLD, where the proposed product is at least as bioavailable as the approved pharmaceutically equivalent product, unless it has some other advantage like smaller peak or trough ratio, or the product has a different pattern of release that is favorable as the approved pharmaceutically equivalent product. What cannot be submitted as a 505(b)(2) application? A duplicate of the RLD that is eligible under ANDA should not be submitted as 505(b)(2). An application in which the only difference from the RLD is that the extent to which the active ingredient is absorbed. an application where only difference is that the rate at which its active ingredient is absorbed is unintentionally less than that of the RLD. So important word here is unintentionally. If it is intentionally less than the RLD, then it will be considered as a 505(b)(2). Patent and exclusivity protection for 505(b)(2) applications is available, and a statement similar to that provided with ANDA application needs to be provided, which means a statement related to paragraph 1, 2, 3 or 4, just like in the case of ANDA, needs to be provided even in 505(b)(2) applications. We will discuss these paragraph 1 to 4 in our class related to abbreviated new drug applications. These 505(b)(2) applications may be granted 3 years of Waxman-Hatch exclusivity if one or more of the clinical investigations other than bioavailability and bioequivalence studies were conducted. There is a provision of Hatch-Waxman exclusivity for the new chemical entities and other types of products, which is also known by the name of data exclusivity. There is one type of exclusivity, which is the marketing exclusivity, which is obtained by filing of the patent. But there is another type of exclusivity, which is called as data exclusivity, wherein the clinical data that was submitted by the company to the US FDA is kept confidential for a particular period of time. And that period is called as the period of data exclusivity. Again, we will be discussing about data exclusivity or Waxman-Hatch exclusivity in our subsequent lectures. Coming to the last slide for today's lecture, what should be included in 505(b)(2) applications? The applicant needs to identify of those portions that rely on information not generated by the applicant or to which it does not have the right of reference. You should also list out the drugs on which it is relying for agency's previous findings of safety and efficacy. Patent information related to drug or the use of drug for which approval is sought. Information to claim the marketing exclusivity. Information on patent for the listed drug. BA/BE studies comparing proposed product to the listed drug. Studies called as bridging studies necessary to support the change from the listed drugs. Listed drugs are the ones that have already been approved by the US FDA. Before submitting the 505(b)(2) application, a plan identifying the bridging studies should be submitted, identifying the components for which the applicant will rely on agency's previous findings. The appropriate division of US FDA will critique the plan and provide the guidance. This helps in catalyzing or helping in the approval of the new drug products by the 505(b)(2) route of approval. So we stop here, and in the next class we'll be discussing other aspects related to the 505(b)(2) applications.